Razor 365.
Hold up.
Hello and welcome to our webinar on Conquering CLM and Contracting Chaos. Today, we will be discussing the current state of contract lifecycle management and the pain points that organizations often face in their contract management processes. We'll share our views on what CLM is and introduce maybe CLM maturity scale and discuss three key elements of successful CLM, people, process, and tools. We will also cover different phases of CLM, the key functions and the tasks involved, and provide insights on how to optimize your CLM processes. Additionally, we will discuss the critical factors to consider when selecting the right technology. In today's business environment, contract management has become increasingly complex, and many organizations struggle with their contracts effectively. So by attending this webinar, you will gain some valuable insights on how to conquer CLM and contracting chaos. The webinar will be led by expert guest, Ms. Lucy Basley. Lucy is an attorney, author of The Simple Guide to Legal Innovation, and the founder and principal of InnoLaw Group. As a former Assistant General Counsel of Legal Operations and Contracting at Microsoft, she redefined how legal work is done and created one of the first managed service engagements with a law firm. In 2015, she was named to the National Law Journal list of outstanding women lawyers and an ACC Value Champion in 2016. In 2021, she was recognized as an honoree of Women of Legaltech by the ABA. Before joining Microsoft, Lucy was an associate at Davis Wright Tremaine in Seattle in commercial bankruptcy and business transaction practices. Lucy is a very well-known CLM expert and the author of CLM Simplified, Efficient Contracting for Law Departments. During this webinar, Lucy will be sharing her experiences and will provide guidance on how to implement an effective contract lifecycle management strategy. Thank you for joining us, Lucy, and over to you.
Thank you so much for having me. My favorite topic. It's morning for me when we record this, so nothing like starting off my day reviewing all of my favorite pitfalls, challenges, questions, lessons learned around CLM. So with that, let's go ahead and jump right in. We're going to start with something quite basic that I love to remind everybody. When we hear CLM, we're often, of course, thinking about the technology, and that is natural. Similar to how we think about the CRM, customer relationship management, and people say, well, do you have a CRM? What they mean is, do you have a CRM system? I think with similarly with CLM, what we're talking about is really a complex web of activities across very complicated enterprises often, that technology is a part of it, but that isn't the only thing. So when we think about CLM for the purpose of this discussion today, and really going forward, for those of you out there who are in this area and do work in this space, it's really intended to make us all think a little bit more broadly than just the technology. While the technology is very helpful and oftentimes necessary, there are a lot of other aspects of improvements that can be made, and that can really be a game changer that don't quite need the technology. So I always want to just remind everybody that CLM is Contract Lifecycle Management. See, technology is not even anywhere in the acronym, but that's what it's become associated with. But we'll get to technology later, I promise you for sure. Just a quick, we're going to take 30 seconds. I am not going to go through this, and I don't expect everybody to read these words. I'll certainly make it available to our attendees. But really, what we've tried to do, again, is to show people that is to show corporate law departments that there are various stages of where they can mature their CLM experience, let's call it that, and we'll dive in deeper into each of these people, policy, people, policy, people, process, and tools. Like I said, it's still morning. I'm only halfway through my cup of coffee here. But all of these streams, if you think of them that way, have opportunities for improvement. And all of them can make a law department more and more mature with how it approaches contracting, commercial contracting, and not necessarily having to make changes across all of these policy, people, process, and tools. So we've tried to create some very easy ways to really, kind of plot a corporate law department on where they are. Are they on a tricycle, or are they, moving into a scooter, perhaps? So this will be available for everybody there. And to be honest, this is always iterating as well. I mean, I always pick my favorite example of electronic signature, and we have that down here at the bottom. That's almost basic at this point. I mean, you have to be using electronic signature. If you're not, that's indicative to me that this law department may not be ready for much more of any other kind of technology if they haven't yet even implemented electronic signature. So that's an example of an indicator for us, for me as a consultant to corporate law departments. We have to figure out where everybody is, even though they might come to us asking for the latest AI piece of technology. We have to kind of walk them back a little bit. So let's dive in a little bit deeper into these various characteristics of CLM, let's say. Okay, let's start with people. And the reason we're going to start with people is it's very simple. It's all about the people. It doesn't matter if you're buying a widget, creating a widget, selling a service, performing a service, it doesn't matter. It really comes down to the experience of people. And we know with technology, focusing on the users and the people who are using the systems is actually what leads to very successful technology. We've heard about user obsession, and everybody knows why they love their iPhones or their Android phones these days, because they were made with the user in mind. Oftentimes, when we hear about technology failures, what we discover is actually the people weren't ready. They either weren't trained effectively, or more often, they just weren't interested in the change. They just weren't really embracing the technology. But let's say we're not talking about technology alone, which is, of course, very much a part of my mantra and my philosophy. Let's talk about who should be involved in the contracting process to begin with. Never mind automation. Oftentimes what we're seeing is that law departments are staffing their commercial contracting work with very skilled, very experienced, and of course that means very costly to the company, lawyers. And that's really the first place to look. Oftentimes you can do significant improvements in your contracting process by really just juggling the professionals that are doing the contracting work and really disaggregating that contracting flow and the contracting review process even, and empowering others to do that work, whether internal or external to the law department, internal or external to the company, if you might need to seek external third-party help, or even within the law department itself. Perhaps it's not an attorney who should be doing the contract review, but perhaps a really capable legal professional, a contract manager, a paralegal, and we're seeing some more progress in the space, but still too often, I have law departments that I work with where it's only attorneys, and that is, I'm going to say by fact, not an effective use of corporate resources anymore. So really want people to spend some time thinking about who in their law department is doing the work. Next, of course, we will jump to, let's see, we have next process. So people, process, and then tools. Process. Everything we do is a process. We don't like to think about it that way. Most lawyers resent thinking about their jobs as a process because we like to practice law. We analyze, we would provide advice. Yes, but in commercial contracting, there is a repeatable set of things that happen. A contract comes, a request for help comes, an attorney starts to do things, an attorney does some research, and then you have to reach back to the business, and you're kind of going back and forth. And then eventually there's a signature and there's a contract is signed. That's a process. That's a flow of activity. And it's very important to step back and look at that process and say, is this the most effective process? Is it the most efficient? My favorite exercise is to do a little process map. Really just write it down. It goes here, then it goes there, then it goes here, then it goes back here again. Why does it go there again? And suddenly you see very clearly on a piece of paper a loop. And if you see a loop, that's always a good place to explore a little bit further and ask yourself, is that loop necessary? And is there a better way for this contract to flow? That's how I think of process, really. Think of it as kind of the flow of contract across a company. Of course, here we want to focus on the role of the law department in that flow. And so oftentimes when you map an entire contracting process, you'll see where legal plays a role. Sometimes it's at a couple of different places, and that's already an indicator that, wait a minute, why is legal being brought in and out? Oftentimes that is a pretty clear sign that there's a bit of a waste of time happening. Anytime we have to switch from working on one thing or one contract to another contract, there's a cost to that switch. So if you're bringing in a law department into a contract review, then out, then back in, before it's gone to the other side, for example, for negotiation, you're already losing some efficiencies there. So, even getting help with something like process mapping is oftentimes very valuable use of time and resource, because it's hard for a day-to-day lawyer to stop their day job and think about process. There's just too much work, and we appreciate that. We understand, but there's some small changes that can be made that would be highly impactful. Then, of course, let's get to tools. I'm going to pause for a second. Let's do one other layer of processes. You'll notice on the maturity model earlier, I had the first row really was policy. And to me, policy and process are often related. I like to call out policy because I think it gets some attorneys' attention, and that's what we want. We want them to think about these different things. But a part of a good, smooth process is also understanding what comes to legal for review when it comes to contracts. Which type of contracts should the law department be spending their time on? A good legal review policy or a threshold policy, or you can call it whatever you want that will make sense in your corporate setting. I mean, words matter, so you want to be careful about what it is. And sometimes policy sounds a little bit too intimidating, perhaps, but it's really the rules of engagement for the law department. This is where the law department has a very clearly written statement that explains to the business when legal needs to be involved in commercial contracting and when the business can proceed independently without legal, which of course means faster. By nature, the more people that are involved in a contract review, the slower it will be. So of course, removing the law department completely can really speed things up. My favorite example is, of course, the NDA. We need to get the business functioning more independently with non-disclosure agreements. Period. Please, let's work on that, because no attorney likes to spend time on NDA negotiations. So part of the process is not just to look at the flow and how it moves, but really that first question of, does legal even need to be involved? And if legal is not involved, boy, that process mapping then becomes another department's problem, and the law department can really kind of step out. Of course, to effectively be able to remove yourself from the process, a law department has to enable the business with templates, with guides, with playbooks, and we'll get to that a little bit later as well. So process is a pretty meaty area and opportunity for improvement across CLM. And then, of course, tools. We're going to spend a little bit more time talking about tools and tool selection. Right now, there's a lot going on in the CLM space. There are a lot of different pieces of technology that are playing a role. There are those that do, what's come to be called end-to-end contract lifecycle management. They do workflow. They do some of the template, creation. They do a good repository and search experience. Those can be pretty complex to implement in large enterprises because it is such a complex workflow, and it covers and touches so many different parts of a company. Those end-to-end systems can be pretty heavy to implement and a long implementation project. Through long implementation projects, people tend to get a little tired. People also tend to get disenchanted, and sometimes people just change. They change jobs, and suddenly you are finding yourself retraining, restarting, and so that can create some discomfort, to say the least. But there are many other tools and technologies that are playing a very important role across different phases of the life cycle. And when you think about CLM, the only way to effectively break down the technology is really to think about the phases of a life cycle and where technology can play a really good part. Some of these phases, maybe technology isn't optimal, or maybe the company just isn't ready philosophically, culturally to embrace technology. But there's no reason that technology couldn't be implemented across certain phases. And even for the implementation process itself, thinking about launching different features where maybe the solution can automate most of these phases of the life cycle, but again, the company or the department isn't ready to just go live with everything being techno magically done for them. So we'll take a minute and just walk kind of across these phases to help, again, orient everybody where technology can play a role, but also another theme I want everybody to keep in mind is where should legal play a role? Which of these phases of CLM are the most impactful for the law department to spend their time? And again, time is money. We know that. And attorneys in-house are expensive resources. So we all have an obligation and a duty as in-house counsel to make sure we're effectively deploying ourselves as resources. I like to have pre-contracting in this phases of CLM because it's a reminder for all in-house lawyers. When we go in-house, and I had this experience from a law firm going in-house to Microsoft, the reason most of us go in-house is we like to be part of the business. Being connected to the business, being a true enabler and partner to the business requires that we spend a good amount of our time before contracts come up. We're working with the business to understand their goals, their vision, their strategy. The contracts then should become a vehicle for all of those goals and strategies. The contracts aren't the job themselves. So we want to spend time becoming really good partners with the business, and we want to spend time preventing the business from even getting into foolish contract negotiations or contracts that we know aren't actually going to come to fruition for a lot of other reasons, because as attorneys, we see a bigger, broader view across the company. We know what audit is looking at. We know where the privacy team is going to have concerns. So that pre-contracting phase is critical, where we really should be spending our highest quality time, frankly, working with the clients, our internal clients. We still call them clients. Let's call them business partners. I think that's the more preferred way of thinking about it. But moving on from pre-contracting, let's get into really the beginning of the CLM phases, especially when we think about automation, and that is that first request for help. The business reaches out to the legal department. And guess what has happened since the pandemic and since COVID time? Requests are coming in every possible way. If before we used to talk about, oh, contract lands on your desk, at 4 p.m. on a Friday evening, physically, somebody comes by your office and throws something on your desk and says, hey, can I sign this? Well, those days have changed quite a bit. And over the last few years, of course, with technology forcing its way into every law department of every size, we now have attorneys receiving contracts not just by email, which of course has been around for 2 decades, but now the business is finding any creative way to get legal's attention and eyes on contracts. And that includes, of course, all the different chat systems, whether you're using Teams or Slack or any other. There are many others, I'm sure, out there. So they come through chat. They come through attaching documents inside of other enterprise systems like CRM systems. Of course, we hear Salesforce often being used for contract lifecycle management. And then I've even heard, of course, contracts coming in via text. That makes lawyers crazy, but it is happening. So and automating the request mechanism is a fantastic first step forward. It's also a quite easy one from a technical perspective. I'm going to give everybody a cheating answer. Start by creating an inbox that is shared across the law department by a handful of people. If your whole department is 5 people, make sure at least just 2 are on an inbox that you can use for intake. So the business isn't going and picking which lawyer or legal professional they want to go to, but they're at least going to one email alias, and then that one can be shared by a couple of people who can then together decide which kind of work should be done by the right people. That's an easy, I'm going to call that a very low tech step in automation, but I'm often sad to see that that's not happening in many departments with more than a dozen people. So that's one simple low tech step, but in a more creative way, of course, you can use existing technologies. If you're an Office 365, company, or you're a Google, a Google Enterprise company, there are ways to create very nice, simple, smooth intake forms, just using the technology that you already have license to. And then, of course, there's the more focused and specific domain CLM-related technologies, where intake, that request, is part of the automation first step, where the business is coming to legal and it's a nice organized funnel, and then it helps, of course, create really interesting data that can be tracked. Who's submitting the request? What department are they in? What kind of a request is it? Does it come with a contract to review, so third-party paper, or are they asking for a first-party template to be created? And of course, automation is a fantastic, easy win, I'm going to say, in this phase. The next phase, you have to create. Somebody in legal has to either create a first draft of a document to be sent to the counterparty for negotiation, or you're creating that first kind of, red line, that first review of the document. That sounds a little bit less like create, because you're really not creating a new thing. You're editing something. But in this phase, especially from a technology perspective, you're often relying on something commonly referred to as a clause library. You're looking at different pieces of other samples that you've done in the past to create a new template, or ideally, you're using technology to help generate a template based on certain parameters that the technology has been trained on. The legal team can create a starting point contract much quicker. Now, the good news is that the legal team can use technology to be faster at creating that initial contracting template. That business can be empowered and enabled to create their own first-party template. Again, let's talk about the NDA. There is no reason why the business can't be empowered to create their own NDA template from some clauses based on a couple of parameters, and a very simple piece of technology can do that. And then you've got the business functioning much more independently without the legal department. In the next phase, we move to negotiation, right, like pre-contracting, but inside of CLM, this is where we want lawyers to spend their time. This is where the best value of the experience and skill set that lawyers have should really be deployed. And this is where we extract the greatest value, that negotiation. This is the back and forth, the give and take, the editing, the redlining, getting on the conference call, and really trying to secure that final position, that final document. Now, technology has made a lot of strides in this space. I would say this is probably one of the tougher spaces to automate, because attorneys like to do things the way they've done them for a long time. They're comfortable with that. Even if they change their position on a particular term of a contract, limits of liability, or they've evolved on the substantive topic, the way they're going to transform that knowledge onto paper is oftentimes using good old Microsoft Word and tracking changes. Even with the advancements of Google Docs and maybe some other competitors and third-party systems that are trying to compete, or editors inside of end-to-end CLM systems, there's still quite a bit of resistance amongst the legal professionals to edit and redline outside of Microsoft Word, which is still the preferred contracting format. There is opportunity to automate here for sure. It exists. The technology is available. This is where the people part of it becomes absolutely critical. Even the best possible technology can't force an attorney to move where they are comfortable editing and tracking changes and redlining, or how they're exchanging the document. The other big part of negotiate, as we know, after redlining and tracking changes, which keeps lawyers from sleeping at night, to make sure every change is clearly there and that they haven't missed a change from the other side. The other big part of course, negotiation is then that exchange of that version, keeping control of that version, remembering what went where. What do you call that document? How do you know when it comes back to you it's the next right version? All of that is mostly done right now in email as well. Vast majority of attorneys are processing their negotiations through email. Technology is available for that, of course, as part of the CLM end-to-end systems, where the document is exchanged through the platform, and the other side receives it, and the platform is able to connect what it's received and how it goes back and forth. Great progress from a technological perspective. Again, changing people behavior is going to be the biggest challenge in automating this phase of the CLM. Now we're going to move to parts where I want law departments to do less and less and less. We have to get law departments out of certain other aspects of CLM, ideally out completely, which I know is shocking, but that's where we want to go. So let's talk about approvals for a minute. Oftentimes, of course, the law department is looked at as an approver of a contract. Did legal approve? Did you send it to legal? Did legal look at this? Is legal okay? Did you get legal to sign off? I mean, these are for some reason, these very simple questions that mean so much to the business, either out of fear, because the law department has instilled this fear in the business, or it's out of self-created fear and concern that I may not know what I'm doing. I better get legal to take a look at this. Sometimes it's under functioning and kind of pushing contracts to legal for approval that legal doesn't need. Again, lots of reasons we get legal involved here, but trying to separate the negotiation and saying, hey, here's that final document that party A and party B agreed to, separate from approvals that really should come outside of legal. If legal was involved in negotiation, legal shouldn't be part of approvals. Approvals should be probably in finance, maybe in IT, maybe there's a special data security team or other special business owner functions. Those are the approvers that we are talking about here. And we want to get legal out of being this kind of general approver, especially if they've been part of the negotiation. Now, if business has been empowered to negotiate without legal, then fine, legal can be an approver. But those are two very, very different functions, and they often get confused. Similarly, approving gets confused with executing. Oftentimes now we have seen electronic signature be used as a mechanism to show approving. Well, again, if the law department was involved in the negotiation, why then are they being sent some sort of it's kind of like a signature, but it's kind of like an internal signature, through the electronic signature process as an approver when they've already been part of the negotiation. Somehow these internal business processes have to be decided before you go to automation. The system has to be taught what you want it to do and where you want it to send the contract next. So the system doesn't magically automate things. We get to tell it what to do. And so this is a great time to stop and ask, what should legal be doing and what can legal step out of? The other thing, of course, with execution, what we're seeing is legal departments are still actually chasing down signatures. First, we're seeing law departments that are responsible for initiating the signature process. And for the purpose of our discussion, we're going to assume electronic signature. But I'm going to pause for a second and beg everybody to move to electronic signature if you haven't yet. That is a requirement. After this webinar, you must initiate electronic signature on at least some portion of your contracts if you haven't yet. There's very, very little excuse to not be using electronic signature. but I will stop my plea and we'll move back to this discussion. Too many law departments are still involved in the execution phase. They are the ones that are creating the electronic, envelope or whatever it's called with electronic signature platform being used. There are several to choose from. Of course, we've got DocuSign, Adobe Sign are kind of the leaders, but there are a lot of very small, very good systems as well, and some that have CLM systems that are end-to-end systems that have signature and execution as part of their own native solution. That's fine too. Whatever gets us out of using pens. We don't want to use pens anymore. But we have law departments whose job it is, for some reason, to start that electronic signature process. And then, of course, because they have started, they're the ones that are constantly then asked, where is it? Has it been signed? Who's got it? Is it done? Where is it? We've got to get legal out of that business completely. That just should not be a part of the responsibilities on the law department. Similarly, storage. Of course, once you have electronic signature, you should be in a place where you are able to store effectively and quickly in a cloud-based solution. That's another very good benefit of electronic signatures. It forces the question, hey, where do we put this when it's done? Where do we want to send it? Don't just have it sent an email. Connect that electronic signature to a storage place, and most end-to-end CLM systems, of course, have that already, native, natural connection. But if you are still in a situation where your law department is allowing lawyers to save as on their C drives, you will have a tough time finding your contracts. And by the way, here's the secret. Problem number one, I call it problem zero, is law departments still can't find contracts. Businesses, enterprises cannot find their contracts. That is a people problem. That is not a technology problem. So storage, do as much as you can to force that cloud storage, because you've already created digital electronic signature. It should be able to kind of make that direct connection so that you're removing that propensity to still store on laptops and C drives. That is a terrible practice. In 2023, which is when we're recording this webinar, we should not be storing any important corporate documents on personal drives. That is actually a pretty big risk. Somehow we had lawyers for a long time saying the risk of storing in the cloud and the data risk and the security risk, but actually storing on C drives is a much higher risk for the document being lost. Not to mention it's unfindable, and people change jobs and people leave companies, and really it's just kind of like the NDA, electronic signature examples. Storage in the cloud is an absolute requirement in 2023. So that's another public service announcement I like to offer. And then one piece of this CLM puzzle, this last phase of managing the contract. Legal should have nothing to do with managing the obligations inside the contract. The contract is, at the end of the day, a business enablement document. Yes, it's got a lot of legal words. Hopefully, they're short words, and hopefully the document is not too long anymore, and we've drafted better, simpler contracts. We want the business to own contract management, the actual management of the document post-signature. It's very important to ensure and enable the business to feel empowered to do this themselves. Lawyers are often dragged in. Where is this? When does it end? What's the termination? Can I get out of this? What's the termination for convenience? It's okay to get advice on a contract, but the business should come to the legal team with that contract in hand, and then it becomes a request for help. They attach the executed contract and say, hey, we have this problem. I'd like to terminate. Can I terminate for cause? That's how we all wish legal advice was thought, but contract management post-execution is definitely not someplace we want legal to spend too much time. Here's another breakdown across the life cycle. Again, we'll make this available to you all. These are, just a description of these different phases and where we think legal should and shouldn't probably play a big role. Now, how do we kind of put this together? We've talked about CLM as, these phases. And when you're thinking about automation, when you're thinking about where legal should play a role, where legal can step back, thinking about it in terms of the phases of CLM, the steps, it makes it clear because you can tackle different phases. Now, to look at it more holistically, we have to realize that all these things work together. If you want to optimize your contracting lifecycle practices, you have to be able to look at it holistically. We've formulated this little house. It helps us help people get their house in order. And this helps people also see, wow, all of these play together. You can't really do one without the other. Even if you think about some of the phases that we talked about, we want to automate something in that, a piece of of that life cycle. You can't just automate without thinking about the why, the how, the who, and that's what we demonstrate kind of with this view. Starting from the bottom up, the foundation goes back to that review policy. What should legal see and not see? The purpose of this talk, this webinar, is really still with the law department in mind. I can't help solve contracting for enterprises. That's I don't want to say anybody else is doing it either because it is so complex. But thinking about the different organizations that play a role in CLM or who own CLM, and I'm asked that question all the time: who should own it? It depends, is my favorite lawyer answer. But for the purpose of our conversation, let's assume the law department is owning it and they're feeling an obligation to improve it, or they've been asked to improve it, or they're stepping in to improve it because nobody else wants to. It has to start with what role should the law department play, because that is the fastest and easiest way to it makes an immediate change, and it sets the entire company on a different trajectory of, oh, well, we thought we had to go to legal for this. Well, it's stuck with legal because legal wants to see everything. Or I used to always send everything to legal at my old company. We see it all the time. So this has to be the foundation. We have to get the law department to be very clear on what it wants to review and doesn't want to review. And by the way, this is an evolving policy. It can start narrow and light and thin and just one type of contract or one type of transaction or one business unit or one geography. You can pick how you want to draft your policy, but you have to start somewhere. And then it can evolve over time and expand as needed. But to have an effective policy, it has to be operational. It has to be clear. It has to make sense. The business has to be able to read it and know what to do next. Now, in order for the business to do things next, the business needs to know its role in contracting, what the responsibilities are on the business versus legal. So that's our roles and responsibilities pillar. And of course, the business has to be enabled with the right contract templates and playbooks. You can't just hand a template to a business and say, hey, I have a new policy. Legal doesn't want to be involved in NDAs. Go do NDAs. Well, you have to explain what it means to go do NDAs, meaning you, business, are now empowered to take an NDA template and send it off to the other side. Fill in the template. Well, I've just now said template, so you have to give them a template, and I have to tell them how to fill it in. What do the different parts mean, and how do we want them to make this template ready to go to the other side? So templates, playbooks, roles and responsibilities, they all are built on top of a policy. And then, of course, the process flows across all of these artifacts, these documents, the training materials, the constant communication between legal and the business. We want legal to spend the same amount of time they used to spend doing contracting steps, educating the business to do those contracting steps. That's a great way to approach optimization, is you move from the doing to the teaching. Of course, we all know, teach someone, give somebody a fish and they will be fed for the day. Teach them how to fish and they will be fed for a lifetime. That is what we want to continuously improve the contracting processes through the right fishing tools, which are the templates, the playbooks, and redefining roles and responsibilities. Only on top of that can you put automation. And again, even if you're putting automation on just one phase of the life cycle, you're still going to need some flavor of template or playbook or a guideline, a policy. I mean, you're going to need something. So automation really does kind of come, on top of that, in my mind. A lot of people say automation is foundation because it kind of flows underneath, and that's true. Once it's there, it becomes kind of a quiet, smooth flowing thing. But for the purpose of launching an optimization project, right? An effort across a company to make contracts better. We find this illustration helps people think about all these pieces. And at the very top, overseeing it, is where you have the law department spending their time. You have the in-house lawyers that really can define what goes in a template, what goes in a playbook, who should be doing what when it comes to contracting. And they get to be part of course, the automation journey. And they really kind of oversee this in many ways, even though we don't want the in-house lawyer themselves seeking out automation. We're hoping they're going to get the help of somebody with legal operations experience or technology project management experience or process optimization experience. But really, at the end of the day, the in-house legal team, especially the general counsel or the chief legal officer, they're the decision maker ultimately in how commercial contracting gets done. So this is how we help people get their house in order. Now, let's do a last couple of minutes on technology selection. Number one question I get every day: what system should we buy? What system should I? What system should I get? Lucy, which system do you like? What's the best system out there? What's the leader, Lucy? Which one should I? I mean, I get every version of this, and we can spend an hour talking about how to get their house in order, but they always come back to yes, thank you, but which system should I buy? There is no one answer. I refuse to answer it because it really comes down to what you're trying to improve. So a couple of things to just kind of put on people's minds. The types of options out there, you need to take some time to understand the different options. The end-to-end technologies of the entire life cycle is really just one type, one key, one big type in this bucket of CLM technologies. And I actually have a visual of buckets we've created to help people think about how their pain in their law department that they're trying to solve aligns with technologies. But there are fantastic technologies that focus very much on contract creation, building good templates, using good clause libraries. There's great automation in just that space alone, and there's fantastic automation for workflow, just workflow. And there's really some really great cutting edge technologies being used and enabled with artificial intelligence. And yes, ChatGPT, can't talk in April of 2023 without mentioning it, in that kind of final phase of storage and managing and data extraction, tracking obligations, researching deviations and variations, a lot happening there. So spending the time to understand the different types of technologies, very important. Next thing to consider and keep on top of your mind, the people. Who are the stakeholders and the collaborators that need to be involved in selecting the right CLM technology? There are a lot of them, and they're going to look a little bit different at every company for sure. Write those down on day one. Know who will be affected, who will be impacted, who can be a champion, who's going to be a user, who can kill this project. Maybe somebody in IT can say, nope, we have a policy against this kind of technology core. You wouldn't necessarily know that, especially if you are a general practicing lawyer. We're not trained to pick technology. That's not our core skill set. So think about the people that can help you pick and think about the people that will be impacted by the choice. Gathering your requirements. This is a whole journey that is often overlooked completely, and you jump to technology, but you don't really know what problem you're trying to solve. Be crisp on the problems you're trying to solve. Be crisp on what are the requirements for this technology? What do we want it to do? What do we need it to do first and foremost? And then what do we want it to do? This becomes an internal negotiation, I promise you. Once you start seeing the options out there for tech, your list of requirements becomes very, very, very long. Don't let it do that. Write down your requirements before you go exploring the systems. Just start of what do you want the system to do? Use your wildest imagination, get that into your requirements list, and then slice it. Remove things, move them to later, and focus on your top pain points as your absolute must-have requirements. And start your selection process with as short a list as possible of what the system absolutely must do, and then have a second list of what you would like it to do. The selection process itself needs to be organized. You need to know which demos you are choosing to have and why. You need to be prepared for the demos. You need to prepare the vendor for the demo. What do you want to see? What do you not want them to waste their time showing you? You need to have a way to write down what you're seeing, what you're liking, what you're not liking, have a form that you use, and there are answers to this. This exists. All of these types of templates and guides exist. Obviously, somebody like me does this every day, but there are ways to create your own and use what you have. An Excel spreadsheet goes a long way, but be methodical through your selection process. Ask the same questions of the tech provider. So you're comparing apples to apples, as we like to say, because it is very easy to get excitable about an orange, but you started by shopping for apples because you were hungry for apples, because you did everything else I just described, and you went to buy apples, but somehow you got excited about an orange. If you try to implement an orange when you needed an apple, it will not sit well in your stomach, let's just say. So be very, very methodical in your process. And then finally, planning for the implementation. Plan, 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 plan. You can't plan too much. Spend the time planning. What features go live, with departments, which users, what is the training, what happens post-implementation? Who takes on this technology? Who's going to monitor, manage it, worry with updates, breaking things, work with the vendor? There is a lot that happens post-implementation that should be part of your implementation planning as well. As I mentioned earlier, we can go on forever. We only have about 1 minute, so I will shoot it over to my co-host here for questions.
Thank you so much for that, Lucy. Extremely informative, and I feel a lot of people would probably relate to this. One thing I feel in terms of questions that people may have is through my interactions, I've realized a lot of law departments may be intimidated by this journey. I mean, of course, for some it might be really long, involving a lot of stakeholders at times, decisions beyond their control. So they often ask us, if I don't want to undertake everything together, is there a starting point for me? Is there a priority where I can start off with? Should I maybe start with legacy contracts, the active ones that I have, or should I focus on contracts going forward? So what would be your suggestions in this regard?
Sure. If they've already committed to automation and technology, they know they want to do that, and they need to show some kind of quick progress on that. They don't have the time to do all the other things that I really do encourage them to do to get their house in order. But if they know they want technology, then I would say there one or two options they have, depending, again, what is their biggest pain point? Are they really having trouble keeping track of the terms inside their contract? Then yes, start with a subset of your legacy documents, cut it off at a certain date. You can't do all. Don't plan on doing all of anything. Just know all, know every, remove those words and say, you know what, we want to look at the last 5 years of contracts, 2 years, 1 year, I don't care, or contracts in this business unit. We want to take all of those and apply a good modern piece of technology to help us categorize them, organize them, and extract key terms. That is a fantastic place to start and prove to themselves that the technology is useful. On the other side of the spectrum, if they want to start with technology and they don't quite know where, they can certainly start with intake. Control what's coming into the law department. Just trying to gather control and data will go a long way to justifying further investments, further time spent on other technology, money spent on more technology. If they can say, hey, we get this many contracts, this often, this time, this is, get some data behind it. And then that helps them with a lot of business justifications for future technology.
I mean, that makes sense. And so one of the other things was, I think there was a report by ACC, I mean, a little while ago, I was reading that one of the reasons for failures throughout this process at times could be lack of maybe expertise in understanding the entire CLM process. So in your experience, what are some common mistakes most law departments make throughout this journey? It could be with technology, without technology, could be process engineering. But what are some common mistakes people actually make, and what can they be prepared for?
Number one mistake I see is the law departments are over-functioning. They are doing administrative tasks related to contracts. They're doing very simple contracts. They're doing contracts that land on, in their inbox simply because they landed in their inbox without asking, why am I even looking at this? That is the number one problem I see as a root cause to the frustration we see with CLM, is that the legal department is somehow, some way, some reason over-functioning and over-complicating where they probably don't need to, but haven't kind of taken that step back to ask themselves the question, what should our policy be? That's my foundational first question. So.
Perfect. So thank you so much for that, Lucy. I think that's all the time we had today. We hope you found this webinar informative and helpful. Contract management is a critical aspect for any business operation, and an effective CLM strategy will reduce risks, improve compliance, and optimize financial performance. I mean, and by applying the insights that we've learned today and the best practices that are covered, I feel organizations can enhance their CLM processes and reduce the associated risks. If you have any questions and would like to learn more about CLM, you can get in touch with us. Lucy is available on LinkedIn as well. We could reach out to her directly. We'd be happy to answer any questions you have. And again, thank you so much for joining us today, and we wish you all the best in your journey. Take care.
Thank you.
You're welcome. So I think that's about it, Lucy. Thank you so much.
Razor 365.